All right. Is it audible now, Manu? Am I audible?
Yes, sir. Yes, sir. Yes, sir. Perfectly audible.
All right.
So,
Yes, let's
good
begin
evening.
with it.
Good evening, sir. Good evening, everyone. Sir, the floor is all open to you, and I'm sure that
Thank
we
you.
all will be embraced from your presence, sir.
Thank you so much. All right. So today's topic is, I hope I'm audible, Manu. I am?
Yes, sir. Yes, sir. You are completely audible.
Is
So
it
your
fine?
video
Okay,
is
cool.
off.
Sorry.
Now it's. I guess your
Okay.
video was off. Now it's completely audible and visible.
All right. Yes. Okay. So I switched on the data. Oh, fine. Perfect. So the topic for today's session is design and trade secret. These are the two different forms of intellectual property that we have to see today, or we have to be sensitized about it. Now, what design law is that it talks about protection to some novel unique designs to the products which are being applied by the producers. Now, a simple definition of the term design, which is provided under the design law, is within section 2D, which says that design is something which is a shape, which could be a configuration, which could be a pattern, which could be a line of colors in two-dimensional form or three-dimensional form, which is applied to any article, and that application of the design to that article is done through an industrial process. So one thing which is very much required is industrial application through which the design is applied to any article. Second thing which is required is it could be 2D, it could be 3D, but it should be aesthetically or it should have it should be aesthetic, or it should have the quality of being appealed to the appealing to the eye. So you should, a person should be able to judge that, okay, this is something which is a new design, which is different, and then it would be that design would be considered as valid design that can be protected under the intellectual property regime. Now, to protect this, previously we have had this design law, design law, which was enacted somewhere in 1911. Post to that, we have had the latest design act, which was enacted in 2000. A very small and a short act. It simply talks about this designs which are being applied to the products and how it can be protected. Registration process is also very simple. The applicant has to submit requisite fees and application to the controller of patents and designs. It would be published for the objections. If there are any objections, there could be a requirement of changing the whatever objectionable part is there in the design. The controller may ask that the applicant has to change the designs, like that particular objectionable part, and if that is being removed or changed, then there would be a registration. Suppose if there is no objection from the public at large, then whatever design you have brought in, that would be registered without without being contested or without any issue. The requirement which is there, or a prerequisite which is there for a design or any design to get registered, is provided under section 4 of the design law. What it says, that it has to have novelty. That means it should be new. It should be something which has not been published previously anywhere in the world. So either it should not be published anywhere. It should not be something which is known to people, that okay, that this design actually exists. Suppose if I have to talk about a comb, so this is a design which is famous, which is known to people. Now if someone comes up with altogether a different design, suppose there is maybe something is a special design is kept here, and maybe it has got some what do you call it, a small device or something. If you push a button, you'll have, a special this shape of the, like a comb would turn up, or like, you can have 3 or 4 different kinds of this combs from that, like a long one, a short one, like whatever, with that device that button, a push button can control it. So suppose if something like that is being created, it would be considered as something which is new, which is not known to people, which is not being which is original, which is being created by the applicant. So the first prerequisite for any design to be registered is that it should be novel, it should be original, it should not be something which is being stolen from somewhere. So I cannot really steal someone's design and come up with the with the criteria that, okay, I would want to register this this particular design. So novelty, originality, it should other than this, it should not be something which is against the public morality, or which is something which is against the public order. So again, these two terms, public order and public morality, is not being defined under the design law, but then it should be understood from its literal meaning, that something which is obscene, scandalous, something which is, which is not morally fit. Suppose that you must have read in the newspaper, there were some producers, manufacturers, who came up with the chappals, the footwears with the with the prints of Ganesha, Lord Ganesha. Now that is something which is morally wrong for us. Maybe otherwise, like, it could be normal for other people, but maybe for the Hindus, it would be considered as something which is morally wrong, which is against their religion, which may have, which may affect the religious susceptibilities of the particular community of the country, or part of a country. So such things would be considered as something which has the connection with the morality, or maybe a public order. So that should be avoided while coming up with the design, or like coming up with the like coming up with a design that you would want to register. Now, other than this, what is required is a design. Design has to be have the capability of being applied to that particular article. Any article, you can't really come up with a like amazing design, a very new or novel design, but then that is not, that has no industrial applicability. So industrial applicability, or industrial application through which the design is applied to any, maybe an ornament or an article, maybe a shape is being created. Jैसे there are so many cold creams जिनके जो teens होते हैं have special shape. So that has to be, it has to be ensured that the design is actually being applied to the article, and it has the, there is a capability of applying this design to that article with industrial application. Now again, other than this, it further says that suppose if there is any design which is merely due to its mechanical use, or mechanical criterion, or technical criteria. So for example, if we talk about maybe a mouse that we use for a computer system, it has a criteria, and because of which that mouse is being designed, right? It has to have a small cursor below, and it should have this this 1, 2, and 3 buttons by which you can control the device. So that is something which is a functional part, which is a technical part, and by virtue of which the design has been created. So you can't really get design right over such small designs, or over such things which are present, or which are applied to any article merely because of their functionality, or because of the technicalities by virtue of which such designs are required. So such designs would not be published. Now, two very famous examples of registered designs are, one is the Crocs, the shoes that the footwears that we use. That is something which is being registered by a US footwear, like one footwear company from US. Again, there was another case also from Delhi High Court. Like there was local Indian local seller who had done what, had started manufacturing this Crocs with little difference. And that company, when it came to know that this Crocs are like, this is actually originally the design of that particular company, US based company, they filed a suit in India, and they could they could win, they could restrain this Indian company from producing such Crocs. So one is the Crocs, and second is the bottle of Coca-Cola. Coca-Cola's bottle is being designed, it has the it is being registered as a a new design. Of course, the term of protection for design is just 15 years. So now it has the term is over, but then it is something which is an example of a registered design. So okay, let's move on the next part. So for what period you can protect your design is 15 years in total. At a time when you make an application, you'll get the design for initial 10 years, and then it is something which can be renewed for another 5 years. So in total, you'll get 15 years protection over your design. Now, other than this, when you have got your design registered, the authors, the owners of that registered designs, they get what? They get a copyright over that particular design, registered design. Now, what is copyright? Copyright, which is defined under this law act, is an exclusive right that the owner possesses over such a design. So you get the right to apply that particular design on any of your articles in any way, within which, that again, there is there are class of goods, and there are class of against which this designs are being registered. So in the concerned class within which you have got your design registered, there you can get your you get the exclusive right to produce, sell, manufacture, transfer, transmit, assign, license, or what else is there? Transmission of your design such products for such class of goods within which you have got your design registered. So that is something which is within design. Now, there is one particular section, which is section 22, if I'm not wrong, under the design law, which talks about piracy of design. It says that suppose if if your design is being misused by someone, how it can be stopped. So how we call in case of patents, in case of geographical indications, trademarks, we call it as an infringement, that there is an infringement of a trademark, right? Now, in case of design, we call that contravention of the right that is being possessed by the owner over the intellectual property, precisely design, that is known as piracy. And section 22 of the design law says that it is something which which is piracy, and it again, section 22 enlists certain acts which would be considered, or which would amount to be be considered as a piracy. Now, what all acts are there? One is, of course, any application of the registered design on by any particular company on their own products, with the purpose of manufacturing and selling and obtaining profit over such products. So if there is a registered design, for example, Coca-Cola's bottle, and let's say any other product, for example, maybe what else? Okay, the box that the Domino's the packaging box that they have within which they pack the pizza, right? Suppose if they have got the design over those boxes, so anyone who's utilizing similar color combination that the Domino's is using, and is again creating similar such box, and they are they have manufactured this box with an intention of doing what? With an intention of passing off their own products, similar products. So I have got my pizza which I am selling. What I am doing is I am utilizing similar such box with the similar design, with the similar color combination, of course with a different name, and I'm trying to do what? I'm trying to pass off my product. So that would be considered as a piracy of the design which is registered by one particular person. Other than this, any import of any design, registered design, without authorization from the owner, honor of the design would also be considered as a piracy. Other than this, with any fraudulent intention, if you are imitating someone's design into your own product, even if the class of registered design is different, it would be considered as something which is a piracy, and it would be punishable under the design law. Now, what are the remedies which are available to the owners of the design is that they can do what, of course, whatever civil remedies that we had discussed yesterday for the geographical indication, that is freezing orders, Mareva injunction, Anton-Pillar order. So there could be different civil orders or injunctions that would be available to, of course, the parties, like either of the party. Other than this, there would be damages and accounts of profit. Suppose if someone has been benefited with the utilization of the design, the fraudulently utilizing someone's registered design, whatever damages are being claimed by the person, that would be paid off, and with that, whatever other profits on accounts are there, that also would be paid back to the original owner. And with that, delivery up of the infringing articles could also be one of the one of the order or direction from the court, if at all that is being also been sought by the owners. So that's how it can be, like it can be the further piracy can be prevented. So this is something which is regarding the design law. We are not getting into the international aspects, precisely the Paris Convention and TRIPS agreement, which talks about the design law with different provisions, because that would be an advanced version. It's not something which we have to discuss here. Okay, one another thing which is very important is unlike geographical indications where the assignment and license is not possible, in case of design, there could be an assignment, there could be a license, there could be there could be a license of your designs given to any third parties or any interested parties. In cases when your designs are being assigned to someone or are being licensed to someone, such person who's taking license has to get himself entered within the muster roll of the controller of the design. So they have to make, there would be an application form, concerned application form as per the design rules. So that has to be adhered to, and with the prerequisite fees, that application has to be made to the controller of design, and it would be the further the assignee or the licensee, his name would be enlisted within the muster of the controller of the design, patents and design. So that is something with regard to design. Now we'll see some what is trade secret. For that, fortunately, I've got a small PPT. So I'll show that PPT. All right. Okay. All right. So and other than this, what we have just seen, the other form of intellectual property which is not yet recognized, recognized as in it's not is not protected as a form of intellectual property in India, is trade secret. We do not really have legislation, distinct legislation in India that protects trade secret as a form of intellectual property. Unlike designs, geographical indication, trademarks, or patents, this is something which is an emerging field, trade secret. What would be a trade secret? We can understand the understand it from its name, right? We do call that is in our normal usual day-to-day conversation, we do talk with each other. Is it your trade secret? Is it something which is your know-how? Is it something which is your own information? So yes, a business which is running amazingly, which is running profitably, would always have one or the other trade secret. And that is, again, trade secret is what? It's something which is an outcome of an intellect, and that is why it is considered as a form of intellectual property. A trade secret would be is known as any confidential information, any confidential practice, could be a process of any business that ensures competitive advantage over its competitors to that particular holder of the trade secret. So suppose if we take an example of this photographs which we are seeing, Google's algorithm is something which is very unique, which is very new, and it has its own know-how. No one has yet been able to copy it, right? Yahoo is there, so many other search engines are there, but they are unable to copy what Google's algorithm is there, like how it is being how it is being executed, or how it is being is functioning. Why? Because it has been saved as a trade secret by the owners. Other than this, we also have got this Coca-Cola's formula. Coca-Cola's formula, that means the recipe behind that soft drink, is something which is known as the most what do you call costly trade secret, and the a trade secret which has been preserved in a very unique way across the globe. How they protect it is they have got only two persons who are at the same time who will be known to the recipe of this Coca-Cola. Again, they'll be knowing it in parts. So one person will know it in one part, the other person will know it in the second part. They both cannot travel together anywhere. They have their own specific agreements with the owners of the this company, and the entire recipe which is there, that of that soft drink, that is being stored in a bank, in a locker, with in which can be opened, or which can be brought out with the resolution of their board, the corporate body that they have. So that's how they are protecting it. That is how they are trying to protect it. Other than that, Domino's cheese dip is very new. Hardly 6-7 years have passed in its manufacturing, but the recipe of the same has been preserved by the company as a trade secret. WD-40's formula, this WD-40's this, what do you call, this bottle you can see here, that has got a unique kind of a glue, chemical glue, which can be applied on certain kinds of the products. Now that creation, that how it is being manufactured, that is something which is a trade secret. Other than that, of course, this Lina Blackbone's baseball rubbing mud is also something which is an open trade secret. And a Big Mac specials special sauce is also something which is a trade secret. So these are simply a few examples of the trade secret. How they are protected? They are protected as what? As they are protected as trade secret within the company. No one can know it. The moment the trade secret comes out or is being disclosed to someone or to the people, it loses its own characteristic, the characteristic of being known as trade secret, and it is not protected. In India, we do not have any legislation that protects trade secret as a form of intellectual property, but we protect it through the through different forms, different provisions of the contract law. One of the provision which is there is section 27. Section 27 of the Contract Act protects it as in form of non-disclosure agreement. That whenever there is an employer and employee who are entering into an employment agreement, employers will will enter into NDAs, non-disclosure agreement, with the employees, and by virtue of signing those NDAs, employees would be prevented from disclosing whatever secret information of the business is there to their competitors or to anyone. They can even be refrained or restrained from joining competitors within a particular period of term, if at all that is there within such NDA. So there was a case in which an employee of a Google had joined Microsoft. Now, of course, there was some software that the persons were creating, and that fellow was someone who was in charge of that software that they were creating, and then that person moved to the other company, which was a competitor company, and the main party had gone to the court, and they could succeed in their claim of refraining the person from joining the competitor by virtue of the NDAs that they have had entered with such employee. Other than this, if we talk about the developed nations, we in India we do not have a specific law, but in case of US has got 3 different laws that protect trade secret within their jurisdiction. So one is the Uniform Trade Secret Act, which is a law which is the oldest law from where the definition of trade secret, undisclosed information, is being imported even in the TRIPS agreement. Other than this, the recent law which is there in US is the Defend of Trade Secrets Act of 2016. They also have got an Espionage Act which provides criminal remedies for the protection of the trade secrets. Now, there are certain questions with regard to the trade secret, whether this is a form of an intellectual property or not, because a property is something which is right in rem, a right which is against the whole world, whereas in case of a trade secret, it is right in personam, because it's a right which a person seeks against the person whom he is knowing. When we talk about employer and employee is the person. So trade secret is a right which is against that employee. It's not against the whole world. You cannot really say, or you cannot really see, trade secret is something which is protected in form of a trade secret until it is secret. The moment people get to know about it, or the moment someone finds it out through a reverse engineering, it's no more secret, and you can't really take any action against such innocent actions of or activities of the people at public at large. They can by their own means they can find out how you have maybe how you are manufacturing any product or how you are running any business. So that is something which is not considered as against the trade secret regime or the protection that has to be accorded to the trade secret. So that there are certain confusions or the differences amongst the scholars, wherein people say that trade secret, whether it's a form of intellectual property or not, that is questionable. However, if we go by the TRIPS agreement, Article 39, Clause 2 of the TRIPS, which talks about the undisclosed information, and if we go through the concerned provisions of WTO, and if we go through this different provisions, it is something which suggests that trade secret is actually a form of an intellectual property. And moreover, if we go behind the jurisprudential aspects by virtue of which the intellectual property law is existing, such as the John Locke's theory, such as the theory, maybe the personhood theory, this theories actually identifies trade secret as a form of trade secret. Again, this would be too much to discuss the things which are behind the intellectual trade secrets and the regime. So let's not get into that. If we talk about Paris Convention and TRIPS agreement, it has Article 10 bis of Paris Convention and Article 39 of the TRIPS agreement. It discusses about the trade secret, and it aims at regularizing this anti-competitive behavior of the companies and preserving the undisclosed informations, know-how, or maybe you can call it as a trade secret. Evolution of trade secret law comes from Roman law to Renaissance, and then Anglo-American jurisprudence also has got its evidences. And how it, if we have to find out the codified version, you can find it out somewhere in the restatement of torts, wherein the trade secret is actually being defined, and that definition is something which we are following everywhere, from the Uniform Trade Secret Act of US to the TRIPS, and then of course how we majorly the international regime identifies it. So that's something which is about the evolution. I'm rushing because this is not something which has to be taught within the awareness thing. This that I have had this slide, so I thought it would be better to show. Now, other than this, if we talk about the trade secret protection in US, as I said, there is UTSA, Uniform Trade Secrets Act of 1979. We have got the Economic Espionage Act of 1996 and 2016 legislation called the Defend Trade Secrets Act. Now, these three laws governs trade secrets within the states of United States. So they have got different provisions, and that's how they are being protected. How it is protected in India, we have got the law of contract. First is, of course, section 27, wherein we protect it as an NDA. The principles of equity and common law action is something which is available for any any wrongs for which there are no specific provisions existing or specific laws existing. So there, therein we can bring in the principles of equity and common law action, and we can file action against people. So that is something which is about the trade secret. We do not really have any law for the protection of trade secret in India as a form of intellectual property, but then it is protected it is protected as an important feature where through the contract laws in the country. So that's about the designs and trade secret. Now, if we have any questions or any confusions, just let me know. I'm ending the session with this.
Guys, if anyone has any question, please raise your hand and unmute yourself and ask. Or you can simply drop your question in the chat box also.
Either way, yes. Again, we are not getting into cases of trade secrets, and we have not gone very deep, because I really don't want to get into the advanced version. I can do that, but it's too early for the freshers, the new students. Yes, Vidita. Yes, Vidita.
Sir, good evening. I actually had a doubt regarding, as you were talking about deep trade secrets and design law. Recently I was seeing a case study regarding China, where they are example for take an example of car, they are copying the designs and the configurations of the leading brands, and they're selling it, but now there is no problem. What is the thing? Is the trade secret and all the laws are different from other countries, or there is some relaxation in the laws? Because
okay. See, first of all, design and trade secret both are different, two different forms of intellectual property. But since it needs lesser discussion, or the legislation is shorter, so we had clubbed that within one particular session. So when we talk about designs and precisely the actions of China, I'm sorry to say, but that China is very famous in copying every any amazing companies or any good products. It's very easy for them. There can be actions taken against that. It is possible for the companies to take actions, but then what happens with Chinese companies is that they do not really reveal the manufacturers or the companies from where it is originated. Usually Chinese products are being created with an intention of dumping it into any country, and then targeting some country's economy. What they do is they'll come up with cheaper versions of this different devices and products or the toys and everything. They'll dump it into your country, and thereby the competition of the horizontal competition which is there at the market level, that would be reduced, or the people that it would be affected, because people would not want to buy of course the people would want to buy cheaper products than buying the costly things. So they'll kick out the best players, market players from any country, and then of course, because it's a dumped product from the China, that would be, they'll get some royalties, they'll get some benefits, they'll get some finances, right? So ultimately, the intention which is there from the Chinese these companies is to target someone's economy and dump the product. So it is not traceable to find that from where this different kinds of the products are being are being originated or are being manufactured. If we talk about cars and all, they do come up with such designs, copying such designs, and this can be prevented, but then again it rests on the companies if they wish to do so, right? You can, or I can also come up with or utilize BMW's design. We can modify our cars and we can create it like a convertible BMW. It is possible for us until it is not noticed by BMW, and until the BMW is not taking any action, it remains not contested, or it remains simply within their domain. So that is something which might have not brought in any actions against such designs created by the Chinese companies. I hope I could reach to you.
Yes, sir. Yes, sir. Thank you so much.
Okay. Do we have any other confusion or a query with regard to design law and trade secret law? I hope this IP Awareness Week has remained useful for the first year and second year students, at least to understand what is intellectual property, and thereby it will help you out to select your specialization. When you'll come in your third year, you'll have to choose your honors paper. And intellectual property is something which is unique these days, because corporate is something which is chosen by everyone, is selected. Every student wants to get into corporate law. Every student wants to get into civil services. So they would want constitution as their specialization. So and criminal law is also something which is fascinating for anyone and everyone, considering the facts of the cases and the the movies that we watched. But then intellectual property is also something which is novel, as such comparatively new field, and it has to be pursued by students who would wish to have the white collar practice. So for that we have conducted this. If we do not have any other, yes,
absolutely, sir. This whole week was very useful, very informative to all of us, and we have definitely gained a lot.
Okay, that's great. Glad to know that. So is there any other question?
And if there aren't any other question, I would request all the participants to please turn on their cameras and Vidita to take the screenshot.
Yes.
And please, all the participants are requested to drop down their name along with their email IDs for the certification purposes.
No one has turned on their camera. Please take their names. This is very bad. I understand that how the virtual classes are being attended, but then at least when your peer is requesting, you should turn on. Where is this Yugul? What are you doing, man? Jyoti, Chintan, Kinjal, Priyanka, Shruti, Mushirali, Paul, Niyati, Yash, Bhutani, Tanmay. Where are you all, guys? आप हो कि नहीं हो? Please turn on your cameras. Let us take at least one good screenshot. आगे से दूसरा एक भी बोलना है बच्चों को कि थोड़े फोटोज भी अच्छे से रखे. तो अगर आपको टर्न ऑन कैमरा नहीं करना है तो टर्न ऑफ भी है, तो एटलीस्ट स्क्रीनशॉट तो हमारा अच्छा आ जाए, ऐसे दिखे कि पीपल आर देयर. Hey, Chintan is there. Okay, glad to see. All right, Vidita, please click a photo with these names which are there, and then for the purpose of updating it. All right, so thank you so much. Thanks to everyone for patiently listening me. And I hope I have reached to you. You have understood something. If you have any further queries or further doubts, you can reach to me through WhatsApp or through email or whatever mode is convenient to you. Right, so you can do that. Thank you so much.
So I, on behalf of Student Council, would like to extend my greatest gratitude to you for clearing all the nuances related to design and trade secrets, and also want to thank KU management and all those who have been closely associated with this webinar session, whole week of the workshop. And without them, this whole week would, flawless flow of the webinar would be an distant hope. And I also want to thank all my seniors and colleagues who had volunteered, and last but not the least, thank you all the participants who are present here. Thank you so much, Shrut sir, for taking these initiatives to conduct such excellent webinars and workshops for all of us. Thank you so much, sir.
Thank you so much. क्या बात है, यश आ गया है. यश, how are you, Yash? Good.
Sir, I am all fine, sir.
Okay. तो मुझे ये नहीं पता चलता तुम दोनों भाई एक ही घर में हो, तो एक ही जगह से ऑनलाइन हो जाओगे तो क्या प्रॉब्लम है?
सर वो थोड़ा सा दूसरे रूम में बैठा था, so
अच्छा, let's save national resources यार. एक ही जगह से दोनों ऐसे आसपास में बैठ के आ जाने का 1 सेकंड के लिए, बाकी it's okay. Anyways, glad to see you. All right. Thank you. I'll leave then, Manav.
Yes, sir, absolutely.
Yeah.
Thank you so
Thank
much,
you.
sir. Thank you so much.
Thanks everyone. Thank you. Bye bye. Have a good day.